Yes, ma'am. Good morning.
Good morning. May it please the Court. Catherine Hinton for Doe 205614, who is a female, despite the name John Doe. The SORB's classification decision regarding a female offender convicted of prostitution-related offenses was not based on substantial evidence in this case. The SORB's rigid reliance on regulatory factors that were designed to assess males based solely on research about males, and its refusal to consider scientific evidence regarding females' exceedingly low risk to reoffend was arbitrary and capricious. The plaintiff's argument has been that these regulations, while normally valid, could not be conclusively applied to assess a female.
So what the remedy you're seeking, I think, is for remand and consider. Is that correct?
Well, I would prefer that this court order her relieved from the obligation to register, but in the alternative for remand and consider.
I guess I was trying to figure out how would we do that, since the question is.
Well, the board hasn't met its burden of proof. The board bore the burden of proof throughout this case, despite the hearing examiner's conclusion to the contrary, that the plaintiff hadn't met her burden. She didn't have any burden. So I would argue.
They could bring it again. Could they bring it again or not?
I don't believe so. This case is
not. It's a civil case. I'm just. So if they've applied the wrong standard, wouldn't you remand it to do it?
Well, that is certainly the alternative, and I've requested that as well.
Okay.
In my brief. This case is very much like a case that was before this court in 2010 regarding age, John Doe 151564, in which this court held that SORB erred in reaching a classification decision without considering the effects of age. The plaintiff in that case, 61 years old, had presented extensive research about age, and the board had refused to consider it because age was not one of the factors listed in its list of 24 factors.
But here, didn't SORB, the hearing examiner, talk about having looked at what was proffered and saying that the regs were basically clear that they were to apply to both genders? It wasn't that he didn't take into account gender, it was that the regs already took into account gender.
Well, the regs don't take into account gender.
But was that the position that he was taking, or am I misstating that?
The hearing examiner stated that the regs say they apply to both genders. Therefore, he was going to apply them to both genders regardless of what the science
And there was
said.
nothing comparable with respect to age in the other case, right?
Well, that's true.
But did he also examine, because your client, or maybe it was you, proffered articles and things, right? Didn't you?
Yeah, there was a different attorney below. But yes, all of the articles,
Right,
with
that
very
you've
small
listed,
exception
yes.
of a couple of articles that no one can find and SORB can't even find anymore. There are 47 some articles that are cited in the SORB regulations, and all of those were, almost all of them were submitted.
But didn't also counsel supply some of the research about females, the lower?
Yes.
And
yes.
and in the decision, because I didn't read the hearing examiner's decision. I just read what the Superior Court did. But in any event, in that decision, did the hearing examiner talk about having read those female studies, if I can use that term?
Yes.
And did he reject them specifically on their merits?
I would argue he rejected them without a proper basis in the record. He rejected them on the basis of a misunderstanding of some of the key scientific concepts
That's what an expert would have done,
that were
you said.
stated in those research articles. In other words, he conflated. There are several different different concepts. There's the prevalence rate, which is that only 5% of sex offenders are female, 95% are male. There's the base recidivism rate.
Right.
Females recidivate at a rate of only 1%. Males have a base recidivism rate of 13 to 14%.
1% apply to prostitution?
Excuse me?
Does that 1% mean there's a 1% recidivism rate for prostitutes?
To my knowledge, there is no specific study about prostitution-related offenses and recidivism rates.
Certainly contrary to common experience.
Well, prostitution itself was not the registrable offense here.
Running a house.
The registrable offense was...
Running a house of prostitution, living off
Exactly.
prostitution of minors.
Exactly, exactly.
What's the official status of all of those reports? Are they the basis for the regulations themselves? Are they intended to serve as guideposts? Are they, what are they? What's
The
their
scientific articles that underlie the regulations? Well, the regulations...
And I guess my question is, depending on what they are, how could he ignore them?
Okay, that's two different questions. So first of all, I would say that the regulations at 803 CMR 1.40 say that SORB is to be guided by the authorities contained within the regulations. And in John Doe 151564, the age case, this court took that to mean the writers of the articles are authorities that SORB should be listening to. So in this...
Like expert witnesses?
Well, in a sense, they are the scientific underpinnings of the regulations. And Dr. R. Carl Hansen, who is the acknowledged leading expert in this field, who is cited throughout many of the regulations as the source for that factor, is the leading researcher in this field regarding females. And there was an article that was written in 2005 before the hearing in this case in 2008 about females, and there's another one further developed written in 2010.
But are they part of the legislative history in that sense? Is it the justice?
Well, if you read the regulations, there's factors. There's 24 different factors, and each factor says, we think this makes someone more dangerous, and we cite this literature, and then it gives a cite. Okay, and what the council did below was take every one of those cites and put them in the record. And what I've done in my brief is analyze every one of those cites and show how they addressed males only. There is no research about females addressed within those cites. So,
Could I move you to a slightly different question?
Yes.
And it's probably an unfair question, so I'll begin with that. With regard to the SDP law, U.S. Supreme Court says it is okay to civilly hold somebody, but only because there is a justification based on mental disease or defect. That there's something about the propensity to engage in sexual acts which justifies it when it would not be justified in the absence of mental illness. Do we have any similar view that this SORB registration system is justified only because of sexual propensities? Because here there's no allegation that it was a sexual propensity. This was a pure economic crime.
that's true. This is an economic crime, and there's none of the research underlying the regulations relates to economic crimes. There are a few economic crimes that are listed as registrable offenses, and this is one of them. The like violation here was deriving support or sharing earnings of a minor prostitute.
So you're suggesting that was an improper factor?
I'm suggesting that the regulations state that they're to be guided by the authorities and that additional factors may be considered. So just like the age case where the board was presented with a lot of research regarding older offenders having a lessened risk of reoffense, here the research shows that female offenders have a far less risk of reoffense. So it should be considered as an additional factor.
So
in a
let's
sense,
assume-
a judicially created additional factor.
Let's assume this is a male, exact same profile. This is all economically motivated, as you would say, therefore not covered by SORB? Because it's economically motivated?
No. I've never argued that someone is not covered by SORB. I've argued that where factors are not scientifically validated, they can't be conclusive as to the risk assessment of that person. And individualized research that relates to different subgroups that is relevant and empirically validated should be used as additional information to assess that person. There is no science, to my knowledge, about the risk of reoffense of economic offenders. But I've searched.
Your client has a very long history of, let's say, inability to conform conduct to socially acceptable standards, a long criminal record involving all kinds of
Not that many kinds. She had a drug problem at the time, which is what explains her conduct. She was a
larcenies and
longtime
all
prostitute.
of
Many
that
of her
stuff.
offenses are actually motor vehicle offenses, and there are no sexually deviant type
But
offenses.
lots
of
of
any kind.
evidence that she really is unable to comply with the law.
She completely turned her life around before she was arrested, before she even knew she was under investigation.
Certainly, and that was a mitigating factor which the hearing officer took into substantial account, classifying her as a level 1 as opposed to a level 2, which had been the board's recommendation.
Well, I would submit that the board did not have enough evidence to prove a cognizable risk of reoffense. When you take the
Cognizable risk of reoffending,
sexually,
well, in the same way she had offended, by running minors as
No,
prostitutes.
sexually, any sex offense.
any sex
Any
offense,
sex.
any sex
But
offense.
certainly that as well.
That as
No,
well.
it's economically driven, not driven by any compulsion. Economically driven because of need for money, for drugs, or whatever reason.
Right.
But it seems as if, going back to Justice Cordy's point, there are two things going on which make this case different than the usual. One, we have a woman who's involved in what is characterized as a sexual crime. And secondly, the sexual crime happens to involve sex as the medium of exchange, but it's not the same, it's not driven by sexual urges.
Which is exactly why the literature underlying the SORB factors and the SORB factors themselves, based on that literature, is simply not helpful in assessing her. That literature is
But
based.
that would be true if it was a male, it sounds like, too, right, wouldn't it? I mean, is there any, when they speak of sexual crimes, is there any things which deal essentially with a pimp? With the likelihood of recidivism with regard to pimping?
Well, I don't know if there's any, there's nothing in the literature underlying the SORB factors relating to pimping, but there is literature that females have an exceedingly low base rate of reoffense.
Focused
There
on-
is not such literature regarding male
That's not
pimps.
focused on the likelihood of a madam being a madam at a house of prostitution. It's focused on somebody engaged in indecent or in rape or indecent sexual touching doing it again, isn't it?
It's based on analysis of 10 different studies. The most recent research article, the Hansen article from 2010, is based on 10 different studies. It's a meta-analysis. It's an international study. It studied 2,490
measuring
sex
sexual
offenders who were
recidivism.
female.
I guess my question is, when they speak of sexual recidivism, is serving as a madam, serving as a pimp, viewed as a sexual crime that's within the scope of sexual recidivism, or is that?
It's probably not within the heartland of what was being studied. And there's a dearth of scientific evidence on
You
that
would
front.
say, I mean, you've got two factors, as they say, but, so you would say, you don't know what you'd do if you only had the pimp situation.
That's not my
That's
client.
not your issue. It's
That's not my
really,
issue.
but it shouldn't become, you would say, the fact that this is an economic crime shouldn't become a justification for ignoring that first of all, the gist of this registration is about sexual crimes, and second, women are just different.
Women are just different. They are motivated differently. They get involved in sexual crimes differently. You tend to have a male co-defendant, tend to have greater victimization histories, tend to have a different psychological profile. This is from the Center for Sex Offender Management, which is another one of the authorities that SORB cites with regard to other factors. So SORB is here picking and choosing which experts they want to cite for some things, and then ignoring what those experts have to say on other things.
Could you tell me, assuming that we agree and assuming that we would remand, what are the factors that would be considered in addition to? What are are there factors, static or otherwise, that are appropriate to apply and consider in this case?
Well, that is why an expert was needed, Your Honor. That the 24 factors that SORB wants to say, these are the only 24 factors we're ever going to consider, those 24 factors are simply not helpful in assessing a female offender. And unless one of those was so blatantly at issue that it outweighed all the other mitigating factors and outweighed the low base rate, I would submit that you know, they're there, but they're not very helpful. And an expert was needed, an expert who's actually studied female sex offense recidivism, of which there are very few, was needed to guide the hearing examiner. The hearing examiner was clearly confused about the difference between the prevalence rate, the base rate of reoffense, conflated different scientific inquiries. So I want to mention that you have before you the amicus brief as well, which raises some constitutional issues that were not raised below and were not raised in our brief. And if there's concern that by adding female gender as a sort of judicially created extra factor that can be looked at in a female case, that males will thereby be able to complain somehow, I would argue that there's a case, John Doe 15606, 452 Mass 784 in 2008, in which this court held that the fact that offenses committed by a male offender on a male victim was used as an aggravating factor, that was okay, and it did not violate equal protection with regard to sexual orientation because it was supported by the science. So where you have science that is clear and undisputed and supports treating a subgroup with specificity, that is what the SORB needs to do to be valid. Thank you.
Thank you.
If it pleases the court, my name is David Chennai, and I represent the board in this matter. There are really three inescapable truths to this case. The first is that the plaintiff trafficked minors in prostitution for profit. Also, the second is that female sex offenders do pose a danger to society. The studies all say that. And the third is that the hearing examiner properly determined that this plaintiff posed a level 1 or a low danger to the public. And that decision was properly made based on the circumstances. He considered the studies that were submitted. In fact, the two studies, and there were only two studies at that time submitted for the hearing examiner. The first one was a 2005 Cortoni
But he
and Hansen study.
he did not allow an expert.
He didn't allow an expert, but what would the expert testify to?
Well, I don't know because he didn't allow it.
Well, the expert, well, if you look at, and this is an important part, if you look at the fact that the studies both say that were submitted, they both say that female sexual recidivism is a wide open question. Nobody has the answers for it because there's been so little research on it. So an expert's basically going to come in and say, I don't have any answers for you because there was no research done on it.
But isn't that, I mean, isn't the fact that he got that all screwed up a reason for having an expert? Because he was, as your sister mentions, confusing the data which speaks about 1% recidivism, which appears to have a large enough sample, with the other data which says in figuring out who is going to recidivate and who is not, because that 1% is so small, we have too small a sampling to be able to do a static 99 equivalent with regard to women. Isn't that what the report says, and isn't that what your expert got all confused?
No.
I'm sorry, well,
First of all, the
that's your
hearing
expert.
examiner wasn't
Isn't that what
confused.
isn't that what the hearing officer got all confused? Is not recognizing the difference between the recidivism rate versus those static, versus the problem of trying to figure out static 99 type factors to figure out which women will recidivate and which will not?
Actually, the hearing examiner wasn't confused. If you look at his decision, if you look at when they were talking about the expert witness part of this, he specifically said, I have two studies in front of me, and those two studies were contradictory. The first study said that, and that was the Cortoni-Hansen, he says 1%, there's a 1% recidivism rate for female sex offenders. The problem with that is the Department of Justice says the problem we have overall is we don't know what the actual sexual offending rate of women are, because they looked at victimization studies and it showed that 63% of women who were sexually offended against were offended against by women, and I believe it was 27% men said that they were sexually abused by women. So underlying the original Cortoni-Hansen, he's going under this assumption that sexual acts by females is very low, which may not be the case. What the hearing examiner said is if you look at the studies, first of all, the Cortoni-Hansen study in 2005 only had 380 women as the cohort. So you can't make any rational judgment. Even the study itself says this is not going to be the definitive answer because lots more research is done. It needs to be done. We have to determine, first of all, what the real base rates are for sexual offending of females, what the recidivism rate would be based on that base rate, and more importantly, once you figure out what that is, you have to figure out what factors may be applicable for female sexual offending, and that those factors may be different. Now, the twist to that is if all the research is done and we have years of research, we may discover that many of the board's factors do apply, or maybe even all of the factors. We don't know.
No,
Well,
the
how do
regs have not been, excuse me, the regs have not been revised since 2002?
I believe they were revised in 2004, but not substantially.
All this research that's been done since then and has not been accounted for in the regs?
It depends, well, no, but the difference is that there's been no research on female sexual recidivism.
well, there's a meta-study in 2010. How can you say there's been no research?
Well, the 2010 meta-study, again, is not definitive on the answer.
No, I'm not asking about definitive. You said no research.
No,
That
no,
is
I
not
should say
true.
very limited research has been done. The meta-analysis covered 2,400 women. That was the total cohort. And out of that, Hansen says, the 2010 study, Hansen says, you got to take 500 of those women right out of there because it's really 1,900. Because what he said is the variable rate was too wide because Van Diver's 2007, his analysis was female sexual recidivism was actually 10.4%, equal to males, which was 11.8%. And what Hansen said is the problem with Van Diver was he used prostitution-related type cases, such as we have here, and they have to be taken out of the equation completely. If you read the Hansen study in 2010, he specifically says we need to determine what is sexual acts by a female that we're going to consider, and he specifically says we should not consider prostitution-related offenses.
Well, but we do.
We do. But what I'm saying is that's why the Hansen study is not the study that we should have to rewrite the regulations for. It really covers 1,900 women, and he says at the very end, it's all still an open question.
Can I ask you this question? The board has taken the position, and the judge agreed, that the regulations as they currently exist are meant to apply to men and women, correct?
Correct.
But do you dispute that all the studies that underlie the factors that the board has adopted are limited to males?
I don't dispute that. What I will
How do they apply to women?
Well, it's not the application to women. What happened was, if you look at what the hearing examiner did in this decision, which was well done, what he said was there are certain, taking those two studies, he
No,
based...
but could you answer my question? How does the board say they apply to women when none of the studies that underlie those factors included women?
Because the studies up to that point were studies that we used to determine general sexual recidivism.
For males?
For males. Now, keep in mind, up until that point, there have been very few, if any, studies about female sexual recidivism. It's very new to the field. Now, you have to look at the fact that the hearing examiner in this case pointed out the factors aren't the absolute law in determining sexual offender recidivism. What you look at, it's a guidepost. And what the hearing examiner did, and did properly, was he said you have to look at what are the types of things that cause general recidivism as well as sexual recidivism. And what he did is he clearly said there are certain things, and the studies agree with this. Antisocial behavior. Well, this plaintiff has antisocial behavior judging from her criminal record. Substance abuse issues. This woman has significant substance abuse issues and actually said running an escort system is like an addiction, that she was addicted to running an escort system. He also looked at the fact that she had only been in the community offense-free for 2 years. Now, in his mind, and I think that most people would agree, that at least shows she poses a danger to society, to the public.
Ask you, what is it, the danger that SORB is supposed to be looking for? I mean, is it that she might be in danger of robbing banks again?
I think
Or
in this,
is it a danger that she will sexually reoffend?
it's that she'll sexually offend.
What does a general recidivism rate have to do with that when all of the recidivism factors are factors studied only in men?
Because the studies that were submitted say specifically that the one thing we can look to as a guidepost for female sexual recidivism would be general recidivism traits, because there's very little understanding at this point as to what factors actually would apply and how they would apply to females.
Doesn't that present a problem for SORB?
No, it doesn't.
It doesn't?
No, I mean, you look at it this way, you look at,
This is like medicine that only tested males for years and came up with studies that generalized to the entire human race. Doesn't it present some kind of a problem for SORB to say we don't really know what causes women to recidivate, and yet we're going to be determining when it's our burden, we have to show that someone is going to recidivate in order to be able to say that they have to register at any level?
well, the reality is the board's carrying out the legislative mandate to protect the public from female sex offenders. And female sex offenders do pose a danger. The studies say that. There's a disparity of what that danger is. Right now, Hansen says it's 1 to 3%, and Van Diver says it's closer to 10.4%. So there's a big gap in there. What the hearing examiner did is decided to follow what the study said, which was to use general recidivism rates at this point until something further can be determined. And that's what he did. And he applied it very coherently and very clearly and plainly, and made it clear that she's a danger and found her to be a level 1 sex offender.
And you think expert testimony by somebody who has actually studied this would have been of no use whatsoever in helping to explain what kinds of factors or how the general recidivism factors might be considered in connection with somebody who is with this type of non-sexually oriented, plainly more economic crime. This is supposed to be an individualized determination. You don't think an expert could have been useful in helping to articulate what kinds of factors might be useful in determining whether or not somebody in these circumstances might recidivate?
Well, as a parallel with the age studies, the court said that the hearing examiner had to consider the age studies that were submitted, and that expert says specifically there's no requirement that we have an expert for age studies. This is similar in the sense that you have studies about gender. The hearing examiner looked at the studies about gender. The studies about gender said there's really no coherent rationale as to how we're going to apply them in the future. So I don't know that an expert at that point is going to be able to go much further than what the study said, but the hearing examiner had the ability, and he did properly consider the studies that were submitted and applied them to the case. And therefore, I don't think an expert was going to make a difference in this case. You know, when you look at the fact that it was all male studies to begin with, that's a slippery slope in itself. They didn't separate the males. They didn't say, okay, heterosexual males have this rate and homosexual or gay males have that rate. Now, does that mean we can't classify gay sex offenders?
Was there a proffer made in this case as to what the expert would have testified to, and did it differ from the studies that were submitted?
The proffer was that the expert would testify as to the application of the factors to her as a female. That was the proffer. And again, the hearing examiner looking at the studies determined that we didn't need an expert for that. He was able to look at the studies himself and make that determination based on what the study said about gender.
So the expert was purely on gender. It was not on this distinction between being a madam at an escort service versus engaging in sexual touching offenses.
I think the proffer actually said that it was a female, how the factors would go to a female and or a non-contact sex
Best
offense.
of both. Okay. Now,
Right.
with regard to all of these studies, do you know whether when they define the sexual offense, whether they included any non-contact offense apart from possibly exposing oneself?
The only study that discussed, even for the female gender ones, is the only study that even discussed prostitution-related cases was the Van Diver study in 2007, which put a very high recidivism risk.
With regard to those who were themselves prostitutes returning to prostitution.
That seems to be the general tenor of it.
But that's not a sexual offense as we define it.
Right. We don't have any research about non-contact offenses. What we have is a legislature who has determined that if you are going to, in this case, induce or live off the profits of a minor prostitute, that there's a danger to minors and that they
Right,
have
well,
to be
I
protected.
understand that, but I'm trying to figure out how a prediction can be made of recidivism based on the likelihood of a madam once again returning to madamhood without any data.
Well, I don't think it's a data issue, it's a common sense issue. Again, you look at what the hearing examiner looked at. She was running 4 young women under the age of 18, one of them as young as 14, as a prostitute. She was, on top of that, she had a substance abuse problem. She also had antisocial behaviors, and then she'd only been really clean for maybe 2 years. I think that shows there's a risk. There's a risk that she could go back. If she starts doing drugs again, does she go back to stay a waitress, or does she go out and do what she knows will make money? We don't know. I know that. But we don't have to prove that she's never going to reoffend.
Okay, well, I understand that, but what you're saying to us is, with respect to that part of the expert testimony which would focus on non-contact offenses, it would not assist, it would not be important to assist a hearing officer who was going to rely entirely on common sense without data to learn about the potential difference that a non-contact offense may have on recidivism rate.
What I'm saying is that an expert doesn't have data on that either. There is, as far as I know, I know of no studies that involve recidivism and non-contact offenses.
But would it not be useful even to know that, even to know what the limitations are of the studies of sexual recidivism, to say you can't use these at all in evaluating this risk? Would that not be something that would be important?
I think you can just look at the studies that are submitted and make that determination, which is what the hearing examiner did.
So you're saying the hearing examiner did go back to the studies and determine whether or not these prostitution-related offenses were deemed sexual offenses as part of those studies, and were used in determining sexual recidivism? Did that?
No, I don't think he did that. What I'm saying is that the studies that were submitted as to gender, he considered. An expert isn't going to change the whole dynamic of whether or not whether or not he had to determine whether there was a non-contact or a contact. The legislature's already determined that for him, that a contact offense or non-contact offenses are registrable and pose a risk. And then you put in the factors from that point on, just like with the female gender. You put in the factors as well as, in this case, other more important factors that are pointed out in the studies themselves.
Well, counsel, we have to leave it there.
Thank you,
Thank you
Your
very
Honor.
much.
Thank you.